6 weeks. That's how long your tenant has gone without paying rent. They've stopped answering your calls, and now you're staring at the lease wondering what you're actually allowed to do next. That situation hits DFW landlords every month. The ones who get through it without losing their shirt all have one thing in common. They understand the Texas eviction process before they need to use it. I'm Michael with Darling Property Management. We manage rentals across the Dallas-Fort Worth Metroplex. And today I'm walking you through the whole process step by step. We'll cover what the law actually requires, including the big changes that kicked in this year under Senate Bill 38, the mistakes I see landlords make over and over, and what an eviction is really going to cost you. Let's get into it. So before we talk about a single notice, we need to talk about the part most landlords skip. It's also the reason a surprising number of cases get tossed at the JP court. Your documentation. In Texas, you carry the burden of proof. So before you file anything, your records need to be clean and easy to follow. Here is what you actually need. First, the signed lease. If you can't put a signed copy in front of the judge, you're starting at a disadvantage you probably won't recover from. Second is your tenant's payment history. Pull it straight out of your property management software. Every payment, every missed payment, every partial payment. The judge wants a timeline they can read in 30 seconds or less that tells the story. Third is your written communications with the tenant. Text, emails, notices, print everything and put it in date order. And fourth and final, proof that you delivered the notice properly. We'll get into the why in a minute, but document the how. The Texas eviction process moves fast compared to most other states, but that speed comes with a price tag. Small procedural errors will get your case dismissed. Every restart is another month without rent on a property in Dallas, Richardson, Plano, or wherever you own. So get your file organized first. Then we can discuss notices in step 1. Step 1 is the notice to vacate. This is the official starting point of an eviction in Texas, and it lives in Texas Property Code section 24.005. Basically, before you can file an eviction lawsuit, you have to give the tenant written notice to vacate. The default is 3 days, but your lease can specify something shorter or longer. Always check your lease first. Now, here's the big update for 2026. Senate Bill 38 changed how this works for non-payment cases. If your tenant was current on rent before the month they fell behind, meaning this is their first miss, you can no longer hand them a plain notice to vacate. You're required to give a notice to pay rent or vacate, which gives them a chance to cure by paying what they owe before the deadline. If they pay in full before the clock runs out, you can't file. If the tenant has been late or short before, you've got a choice. You can use the pay or vacate notice or the standard notice to vacate. Either is fine. What the notice itself needs, the reason for the eviction, the date you're serving it, and a clear statement of the deadline. And then there's how you deliver it, which also got an overhaul under SB 38. You've now got 4 valid methods. You can mail it, either first class, registered, certified, or by delivery service. You can leave it inside the property in a conspicuous place. You can hand it to any tenant on the lease who's at least 16 years or older. Or if your lease specifically allows it in writing, you can deliver it electronically, by email, for example. One thing to flag. The old rule that added 2 days to your notice period for mail delivery is gone under SB 38. And there's a new safety net. If the tenant actually received the notice, the delivery method probably won't sink your case. That said, don't get cute. Use one of the 4 methods, document everything, take a photo of the posted notice on the door, save the certified mail receipt, date everything. If the tenant pays in full or fixes the violation within the notice window, the process stops. If they don't, you move to step 2. Once the notice period has fully expired and the tenant hasn't complied, you file the eviction lawsuit, also known as the forcible detainer suit in the Justice of the Peace Court. You file in the JP court for the precinct where the property sits. not your home precinct, not the main county courthouse, the JP precinct that covers your rental address. Get this wrong and your case gets dismissed. Filing fees vary across DFW. Most counties run somewhere in the $100 to $150 range for the initial filing, plus an additional service fee for each named defendant, usually less than $100 per person. Call your specific JP court before you go to confirm the amount. You'll fill out a petition for forcible detainer, which is pretty straightforward. Bring your lease, your notice with proof of service, and your payment ledger that we talked about earlier. The court will set a hearing date, usually 10 to 21 days out. They'll also issue a citation that gets served on the tenant. It's important to note you don't need an attorney to file. As an individual landlord or through an LLC you own and manage yourself, you can represent yourself in JP court or let a property management company like us handle that for you. But, and this is important, if the case is contested, the tenant claims that they paid, they raise habitability defenses, or file a counterclaim, get a property management attorney involved. Legal fees almost always cost less than losing the case and starting from zero. And don't sit on the filing. Every day you delay is rent you're not collecting. On an $1,800 a month rental, for example, that's about $60 a day walking out of the door. Next step is the hearing day. This is where landlords either close the case cleanly or fumble one that they should have won. Bring everything. The signed lease, the notice with delivery proof, the full payment history printed out, not pulled up on your phone. Any written communications and photos if they're relevant. Just bring all of your documentation. Show up early, dress like you take this seriously, because I can assure you the judge will take it seriously. The hearing itself is usually quick, 15 to 30 minutes. The judge hears both sides. The tenant has every right to put up a defense, and you need to be ready for the common ones. You'll usually hear three. The first is, I paid the rent. You can counter that with your documented ledger, dates, amounts, the methods. You can show the gap and tell the story. The second is, the landlord didn't fix repairs. That's that habitability issue that we talked about. And it's why we log every maintenance request and response in your system. Bring your maintenance history and any vendor invoices to counter this claim. The third is that they never got the notice, and that's why you photographed the posting and saved the receipts. For cases filed on or after January 1st, 2026, there's also a new wrinkle on the appeal side. If your tenant wants to appeal, they now have to file something called a verified notice of eviction appeal, where they swear they have a legitimate defense and aren't just stalling. Doesn't change your job at the hearing, but it's worth knowing the appeal bar got slightly higher. If you win, and with solid documentation you usually will, the judge issues a judgment for possession. The tenant has 5 calendar days to appeal. If they don't, you can move to the next step. If they do appeal, the case goes up to the county court for a brand new trial. That process takes longer, and it's the point where having an attorney really matters. But for clean, non-payment cases, the vast majority resolve at the JP level. If the tenant doesn't leave on their own after the judgment or after losing on appeal, you request a writ of possession from the JP court. The writ is the court order that authorizes a constable or sheriff to physically remove the tenant and their belongings from the property. There's an additional fee for the writ, varies by county, but expect to pay anywhere from about $150 up to $200 or more. For example, Dallas County's JP precincts are currently typically around $200, maybe $210. Once the writ is issued, the constable posts a 24-hour notice on the front door. After that 24 hours is up, the constable comes back and supervises the lockout. And here's the part I want to be really clear about. In Texas, you cannot lock the tenant out yourself. You cannot remove their belongings yourself. You cannot shut off their utilities to push them out. That's all illegal under the Texas Property Code. Do any of it, and you're looking at damages, attorney's fees, and possibly losing your eviction case altogether. Just let the constable handle it. That's literally what the legal process is for. Once the lockout is done, your property is back. Document the condition with photos, do your security deposit accounting under Chapter 92 of the Property Code, and get the place ready to release. So now let's talk about some common mistakes landlords make in this process. Mistake number 1 is bad notice delivery. Slipping it under the door, taping it to the outside of the building, or emailing it without written authorization in your lease. Any of those can sink you. Stick to the 4 methods that we discussed earlier the statute actually allows. Mistake number 2, again, as we discussed earlier, filing in the wrong precinct. The JP court for the precinct where the property is located, not where you live. Get the precinct wrong and you're starting over. Mistake number 3, filing before the notice period is up. You can't file a forcible detainer suit until the full notice window has expired. If you file on day 2 of a 3-day notice and the case, well, quite frankly, gets dismissed. Mistake number 4, accepting a partial payment after you've already served notice. This one trips up a lot of people. Take any money from the tenant after the notice goes out, even a partial payment, and a court can read it as you waiving the notice. You may have to start the whole process over. Before you accept anything once an eviction is in motion, call an attorney. Mistake number 5 is thin documentation. No lease on file, no payment history, no proof of service. You're going to have a rough afternoon in JP court. Mistake number 6, trying to handle removal yourself. I'll say it again because it matters. Changing the locks, removing doors or windows, shutting off utilities, all illegal. Don't do it. Let the constable or sheriff do their job. So now let's talk about eviction costs, because when landlords ask me about eviction costs, they almost always lowball it. Court costs are the smallest line items. Filing fees, roughly $100 to $150. Writ of possession, another $150 to $200. If you hire an attorney for an uncontested eviction, plan on $500 to $1,500. If it's a contested case, you could be looking at $2,000 to $5,000 or more. But the real cost is the one most landlords don't add up, and that's lost rent. From the day rent stopped coming in to the day a new qualified tenant is paying you, even a smooth eviction in Texas would run about 45 to 75 days. On a $2,000 a month rental in Plano or McKinney, you're already looking at $3,000 to $5,000 in lost income before you fixed a single thing. Then add property damage above the deposit. Add your own time, paperwork, court appearances, the stress of managing it all. Add the cost to release the property, photos, listing, showing, screening. Suddenly, a single eviction can run a North Texas landlord $5,000 to $10,000 all in, which is exactly why we put so much energy into screening on the front end. The best eviction is the one you never have to file. If you own a rental in DFW and you'd rather not be the one going through this, or you're already in the middle of a tough tenant situation and want a team handling the steps for you, let's talk. There's a link in the description for a free rental analysis. No obligation. We'll tell you what your property should rent for in today's North Texas market, and we'll walk you through how we manage everything from screening to lease enforcement. Just a quick disclaimer, everything in this video is educational. Based on the Texas law as of 2026, including the Senate Bill 38 changes that took effect January 1st, if you're in an active eviction, especially a contested one, talk to a licensed attorney. The specifics of your situation matters. If this was useful, hit subscribe. We put out new content every week for North Texas landlords who want to treat their rental like the business it is. I'm Michael with Darling Property Management. See you in the next one.